everyone, and welcome to Real Property Pros and Cons, episode number 6. Today, we're going to be talking about a really interesting topic, which is small claims. I think that a lot of people don't really know what small claims is, or they kind of have heard of small claims, but they don't really know how to use it. And so there were some really interesting news stories that came out, not necessarily in the past week, but in the past year or so. There was one really funny story. Apple sued for $1,383.13 for refusing to fix iPhone under warranty. Essentially, this guy bought an iPhone. He found out that the iPhone wasn't working. He got really upset when Apple said, hey, we're not going to fix it based on our warranty. And then he decided he was going to take him to small claims court. In addition, there was another story that came out against Facebook. And I'm really sorry, big tech companies, but these are the two that came up. Small claims judge rules against Facebook in Oculus case, orders tech company to pay legal fees. So, essentially some guy bought an Oculus Quest for his kid. The Oculus wasn't working. And he was like, hey, Facebook, please fix this. Or, hey, Meta, fix this. Although they were Facebook at the time he sued them. And they're like, no. And so he sued them. And the judge ordered that they pay his court fees and also that they pay $1 in damages. And really great outcome. He got another Oculus Quest for his son after having sued them. So anyways, what we're going to be talking about today is what is small claims court, when can we use it, and what exactly is the purpose of having a small claims process. And also, our guest is going to kind of demystify the small claims process and make it seem a little bit less scary than it actually is. And so we'll be right back with our wonderful guest. Hi. Hello, everyone. All right. So we have our guest here today, Pamela Brown-McGill. Pamela Brown-McGill is an attorney. She obtained her undergraduate degree summa cum laude, which is a fancy Latin term meaning she was super awesome, while raising her 3 children. And she volunteered for various activities and also worked full-time and went to school. So she had, 2, 3 full-time jobs? Worked full-time, volunteered full-time, had kids. So yes, you had 3 full-time jobs, which means did you sleep during that time at all? Okay. And attorney Pamela has worked in the legal field for over 20 years, and she worked her way up from being a legal secretary trainee to being an attorney with her own practice. And she is now an attorney with her own practice, and she is here with us today. And she understands not only the substantive areas of the law, which is, like what the law is, but also just like the procedural requirements and all of the stuff that attorneys like me who have never really worked their way up don't know about. They're just like, that's for the secretary, or that's for, whoever. We don't know what are filing deadlines. And during Ms. McGill's long career, during Pamela's long career, she primarily worked in the public sector, and she worked in civil litigation as well as labor and employment law. And during her last years before becoming an attorney, she and opening up her own law firm, she actually worked in the state court small claims legal advisor's office. So as I understand what they do, you spend all of your time on the phone talking to people who have all of their random things like, my hairdresser messed up my hair. Do I have a small claims case? So that is what she spent all of her time doing. She believes that knowledge is power and continually seeks avenues through which to empower others with knowledge. Thank you for being on our show and doing that for our viewers. And now her practice expands to include bankruptcy and estate planning, as well as small claims consulting. She runs the small claims clinic at Thomas Jefferson School of Law. And she offers free consultations, which I'm sure we'll talk about later on the show. So, Pam, thank you so much for being with us. Thank you for, uh, you know, chatting with us and letting us know about your expertise as it relates to small claims court. So,
Thank you
I
for
guess,
having me.
oh, you're very welcome. So, I think the very first question is, why is it small claims? Are there big claims courts?
I love the way you put that. Yes, there are. And we don't call it necessarily big claims court. We call it, we have small claims, and then we have our civil limited and civil unlimited court.
Okay.
So I kind of like to refer to it as big court and baby court sometimes.
Okay.
Kind of make it more appealing, more accessible. You want to kind of pull it in.
Yes, definitely we do. So what exactly does, small claims court do? And you said there's small claims, there's civil limited and civil unlimited. It sounds like there's like, you know, kind of like a Goldilocks system, right? You have one that's too small, one that's, too big, and then one that's just right.
I love that analogy, but I'll tell you something. A little bit different than the Goldilocks syndrome is that even though you might say, oh, well, that's too large, let's go to the next level, or that's even larger, let's go to the next level. The cool thing about small claims is you can actually you can reduce the amount of your claim down to an amount and squeeze it into small claims. So let me go ahead and demystify all of that legalese, which I try so hard to avoid. But was that even legalese or just a bunch of gibberish? Anyway, another story. The bottom line is this. If you want to sue in small claims court, the only requirement is that what you're suing for is less than $10,000. As simple as that. The cool thing is this, you know what? So what? Maybe you have a claim for $12,000 and you're thinking, do I go to the next level, which is our civil limited, where you can sue up to $25,000, and then basically find myself maybe having to go toe to toe with an attorney as a layman, or maybe have to hire my own attorney to go against this other attorney? Or do I say, you know what? Maybe I don't need the 2,000. Maybe I'll save myself some money and I'll go ahead and squeeze it into small claims for the 10,000. And then the big court, which we're not even going to touch, is our civil unlimited. And it's just what it says, unlimited. If you want to sue someone for more than $25,000, you go over there. But for the rest of you, you stay right here in small claims, and we'll talk a little bit more about this.
Right. And are there some differences, like other than what you said about like attorneys and not having attorneys in, small claims court versus civil court? Are there some other differences? Like, is it more expensive to file in civil limited or unlimited court, possibly, or?
Yeah, so when we're looking at your filing fees, there's a considerable difference. If you want to go ahead and file for more than $25,000, you're looking at filing fees of $435. If you want to go to your civil limited, the next lower level, you're looking at $370. Guess what, guys? You can file the same claim, only $10,000 though, for $75. And generally speaking, what's going to end up happening is you prevail in your case, then you end up prevailing. And mind you, $75 is the top amount, right? We're talking about if you're suing for the larger amount. But if you're suing for, say, up to $1,500, excuse me, your filing fee is $30. If you want to sue for 1,501 up to 5,000, then it goes up to $50. And then 5,001 up to $10,000, then that's where the $75 fee kicks in.
Okay. So it sounds like it is a lot cheaper to file in small claims court, and it also kind of sounds like if you've got like a claim for maybe 10,500, maybe you just say goodbye to those $500 because you're probably going to be spending those in filing fees.
Exactly.
And do you get those filing fees back from the other party, or is it part of the judgment, or is it just kind of like the cost of?
Nope. If you prevail, the court automatically adds those fees right in for you. So you don't even have to ask for them. The court knows exactly what you paid when you file your action. So we're going to throw it in there. Unlike if you go ahead and say you file a civil limited case or unlimited, and if you prevail, you actually have to file a motion to get additional fees back. So it's kind of nice that you don't have to go through those extra hoops.
And when you say file a motion, what exactly does that mean and what does that entail?
Filing a motion entails getting a hearing date, filing more, pay more filing fees, getting an attorney, having case law, and basically just doing a lot of work that you're, as an attorney, I don't want to do, and I can't imagine any layperson wanting to do.
And if you are a layperson who wants to do it, you probably are in the wrong profession if you're not a lawyer.
Yes,
just gonna throw that out there for all people. So, in addition to kind of filing fee differences, are there other differences between sort of small claims versus civil court that might make somebody actually want to file a small claim?
Yeah, well, a couple of big differences are, and I did mention it briefly earlier, is that in your regular civil limited or unlimited court, you can bring an attorney, okay? But when you're a small claims court, no attorneys are allowed. So what's the beauty of that? You mentioned earlier the cases against Facebook, right? And so guess what? You sue Facebook in small claims. Facebook cannot drag some high-priced attorney who's, going to go ahead and take you through the ringer in a small claims court. No, it allows you to be on, you might say, or I like to call, an even footing with other party, right? And then the other cool thing is, you're talking directly to the judge. When it comes to rule of courts, because you are talking to the judge is a fact finder, right? So you don't have to worry about, am I using the right words? Right? Do I need to go in with any special knowledge? No, you go in with your evidence, right? That proves your point, and you just explain to the judge why you should prevail. Okay. Now I was going to say that may sound a little bit too simplistic, but I want you to know that sometimes people overcomplicate it a little bit. Okay. So you don't have to do that. So I love that attorneys cannot go into small claims court. The other beauty is that it's a quick process, right? I talk to people all day long, and maybe they do want to, they want the $12,000, but it's like, okay, do we want to spend the next year and a half going after $12,000, an extra $2,000, whereas you could file in small claims court and possibly have your case done in, within the 3-month span. From filing to getting the hearing date. So very quick process, low filing fees, no attorneys. I mean, I think that's a selling point in and of itself. Listen, guys, don't get me wrong. I love my job. I love my colleagues. I love what we do. But I also love that there's an avenue here for the average person that just doesn't want to deal with attorneys and maybe can't afford it, because that's really the reality of it.
Yeah, and I think, since you are an attorney and I'm also an attorney, one of the things that we attorneys love to do is fight about, procedure, or, can you allow this evidence? And if this evidence is allowed, what is it allowed to actually be used to prove? Like, you're allowed to use this piece of paper to prove that the piece of paper exists, but what's written on the piece of paper is not actually evidence, just that there was a piece of paper. And I think that for a layperson, it kind of is just like, why am I paying you all of this money to fight about this?
Exactly. And so the cool thing is, when we talk about those evidentiary rules, which as attorneys, we're bound to follow, and we adhere to. And you're right, we're going to get into big, long, drawn out battles. You could have a motion on whether or not to allow in a piece of paper, which is evidence, right? But in small claims court, because you are before the judge is going to let it in, and he's going to decide, right, what's relevant, what's not relevant, and what to use. So it makes it a little bit easier, I think, for your lay person. You don't have to get caught up in that, and you don't have to pay anybody else to fight about that kind of stuff.
Exactly. Or just to point out, or she, because there are definitely female judges now.
That's right.
And I think you would be an excellent judge, woman or man. So I think one of the things, I think you'd be an excellent judge, but I mean, I do actually think one of the real questions is, do you find that in small claims court, when people are going in front of judges, do the judges actually sort of demonstrate that they care about the people, or do they try to really, help the litigants, the people who are in court, or are they sort of acting more as advocates or like attorneys?
Okay. Well, you know what? I'll tell you that I feel like that question is a little bit of a landmine. So I'm going to go ahead and I'm going to tiptoe very carefully through this. The reality is this. Come on, let's face it. We're all people. Okay. We all have our biases, whatever they may be. Meaning that, you know what? Some judges may be a little bit more patient, some may not be patient. Okay. You're going to have some that are just die-hard small claims judges. They're advocates for it. They want, the lay person out there to go ahead and have their day in court. And you may have some, and guess what? This isn't the big trial of the century that they're presiding over, but this is what they drew that day. So it runs the full gamut. And so I just like to tell litigants that when you go in, sometimes less is more, right? And keep in mind that the judge or commissioner or pro tem or whoever is going to be hearing your case at that moment, they have looked at your papers. So the first line of proving your case, you might say, is just making sure you have a really succinct reason listed on your paperwork as to why you're even before the judge or the commissioner or the pro tem. So save some time, let them know exactly why you're there. And then when you go before them, just be prepared to stick to the topic, right? Sometimes, boy, there's been so many cases, you'll get litigants coming in and maybe they're fighting over the fence, right? Who should repair the fence? But then we all of a sudden are hearing about loud music. We're hearing about how their kids are coming in at all hours of the night, and how they really haven't liked each other. And I don't know what bearing that might have on who should pay for the fence, unless we're saying that the kids partying all night knocked down the fence. Okay, so definitely we want to stick to the topic and not go off brand, because they will, regardless of, they can have the patience of an angel, but they may end up getting a little bit frustrated at a certain point. And I think you're muted.
Yes, I was gonna say, I think that in a lot of situations, if you are ever in a situation where you actually have to sit and listen to 40 people tell you a different story over the course of 4 hours, it is a lot of work. It is very difficult to sit and listen. So the easier you can make it for a judge, I think the more likely the judge is going to rule in your favor. So if it's like very complex and there's all these, ins and outs and all of these aspects of the story, and it's like, well, in order to understand what happened a month ago, we have to like go back 10 years. Like, you kind of lost the judge. And, that is good advice, not just for small claims litigants. That's also good advice for, attorneys in court as well.
True. We have to take our own advice sometimes, which we do, sometimes forget, right?
Yes.
And you know what? Another thing that I wanted to add also is that it is a good idea to, if you are going to be presenting evidence, also make sure that that's on topic. No joke. I've seen people show up in court with like 50 to 100 pieces of pages, and like 90 of them have nothing, 40 to 90 have nothing to do with what's going on in the case. And if we were in regular court, all kinds of motions to quash it would probably be filed.
Right.
So we definitely want to make sure that we're sticking on top of our paperwork in our presentation, as well as when we're presenting the evidence.
Right. And definitely, I know that a lot of times, when there are, 100 pieces of paper, judges really do want to do a good job and they want to come out with the right outcome. So a lot of judges will just say, I will take this under submission and read through your, 100 pages of documents before I help you make a decision or before I make a decision.
Exactly. So you want to be able to just, you want to get in and out. And then I don't want to demean anyone here, but one thing that I found myself often saying to litigants, especially when I worked at the court and, we were advisors, and I'm not saying anything necessarily confidential here, but yes, we are all unique individuals. However, there are only so many types of disputes out there. Okay. So what does that even mean? And as harsh and callous as this may sound, if you've seen a security deposit dispute case, you've seen a security deposit case, you've seen a security deposit case. What does that mean to you as a litigant? It means that's good for you, right? That's great, because that means, guess what? The judge already knows the law. The commissioner already knows the law. The pro tem already knows the law. So kind of keep that in mind. We want to, yes, it's personal and unique to us, but on the plus side, they have most likely, the hearing officers most likely already heard it. And so you don't have to belabor any points there.
Yeah. I mean, I think it's kind of like open heart surgery or, appendicitis. Like if you've taken out one appendix, you can probably take out more than one appendix. Same is kind of true with the law. Like if you've seen one security deposit case, it's kind of going to be the same over and over and over again.
Exactly. And what I wanted to do, Frantz, I mean, if you don't mind, I want to just jump in there real quick. And you know what? I wanted to share with your viewers, if they want. Now, right now, we are talking about what's called the procedural part of small claims, right? This is what's going to get you into the court to start before you even get to your case. And we're going to go ahead and in a bit, we'll go ahead and talk about the actual types of cases that come before the court. But if you want to learn about small claims and figure out some of the do's and don'ts, you have lots of resources. First off, you can go to courts, that's COURTS, courts.ca.gov, and there's a self-help link there. And I mean, it's amazing. You can click on it and they will go ahead and, show you all the different forms that you need. And actually, a lot of our courts have free advisory services. So you can call in and get assistance there. As Ron's mentioned earlier, we have a clinic at Thomas Jefferson School of Law, which is downtown. We do it virtually. And also, I wanted to throw a code section, and don't be intimidated, guys, or overwhelmed by this. But you want to be a little bit familiar with what's called the Code of Civil Procedure, CCP. And if you go to the Code of Civil Procedure, Section 116, and you know what, cool trick here, I'm learning this, just Google it. It'll pop up. The statute will come up for you. And starting there, you can learn about small claims, right? It'll tell you about the amounts you can sue for. It'll tell you about like the timelines in which the cases are supposed to be heard, the types of matters that can be brought. It's just kind of a cool read if you're like me and you love to read stuff like statutes and legislation. But it's also
That's why you are a lawyer.
So, and then just go for it, Frantz. What were you thinking?
Oh, no, I said that's why you're a lawyer.
That's why I'm a lawyer. Exactly. But guys, again, and then just to, just demystify this a little bit more and break it down, when it comes to the small claims process itself, it's really nothing more than getting your paperwork, is called SC-100. It's called a plaintiff's claim and order form. Okay. You're going to fill it out. You're going to put in your name. You're the plaintiff. You're going to list who you're suing, right? The other party, the other company, whoever it is. You're going to list the amount you're suing for, why, and there's a few yes, no questions, and you're done. Does it get any easier than that? I'm going to tell you.
It does not. And as somebody who has suffered, like truly suffered through doing court filings, I can tell you it does not get easier than small claims court.
It's wonderful. It's wonderful. You take that baby to the court, you file it, you pay your $30 to $75 fee. The court clerk is going to, if these days we're doing things a little differently. Before you take your paperwork in, you get a hearing date on the spot. Sometimes they tell you to drop it, they'll mail it to you. In any event, you're going to get a hearing date 2 months, maybe 2 to 3 months down the line. I mean, listen, there's no way you're getting through civil limited or unlimited in that. I mean, it's not happening. Okay. You're lucky if
No.
you get through there in a year and a half. Okay.
No, that's true. And then with, small claim, or not small claims, with landlord tenant, I mean, really good luck. If you are a landlord trying to evict your tenant in the state of California right now,
like you said, good luck. Oh my gosh. Oh my gosh. So yeah, so I mean, it's a cool process. You get your hearing date, you serve the other side, lots of easy ways to serve them, and you show up at your hearing and you pitch your claim, and that's it. And literally, I spent 3 minutes talking to you. About 3 minutes is how long it would take you to fill out the paperwork.
that
Okay,
is true.
you might need my help, but you know what? That's fine.
Yeah, I mean, I think that is totally true. And, I think where I would kind of like to slightly move to is, the show is called Real Property Pros and Cons. So, we want to know when you own real property, when you are a homeowner, where might small claims actually help you? Because obviously, we've talked about, I mean, what do small claims courts hear? What disputes do they hear about?
My gosh, I'm so glad you asked that question. You know what? Let me ask you this. I'm going to ask you a question, okay? Practicing my interviewing skills. I don't know. You may need a stand-in one day. I don't know. But have you noticed that, since COVID, there has been just like tons of home remodeling and improvement projects taking place, right?
Yes.
Right?
COVID has caused me to learn about, the required elements of a construction contract. I didn't know that there was a statute in California that said, if you have a construction contract, this is what it needs to have. Now
Exactly.
I know.
Exactly. So that alone is just huge for homeowners. Okay, just that area alone, because contractors are regulated here in California. Interestingly enough, I did not realize though that did not apply across the country, because some states merely require that their contractors like have a business license. Here in California, depending on the type of contractor you hire, they better be licensed. Okay. And if they're not, and depending on, oh, you're muted.
Oh, I said a contractor's license, not just a
business license.
not just a business
Exactly.
license.
Exactly. And you need to have a specific license geared to the type of work that you're doing. That is so important. I'm going to tell you guys why. You hire a contractor to come out to do a $5,000 project, and it turns out they're not even licensed. They just have performed illegal work.
Well, they've also performed free work.
There you go, right there. Let me share a story with you. When I first started doing small claims ages ago, there was a story that was circulating that apparently, I guess this goes both ways, because I felt horrible for the contractor. So if any of you homeowners out there happen to be contractors, please get your license, please. But apparently, this homeowner made exponential remodeling, or did exponential remodeling to his home using unlicensed contractors.
Oh.
Yes. So what did that mean? That meant they came up, they did the work, and then they presented with the invoice, and it was like, yeah, so sad, too bad. You guys are saying, what? I don't have to pay my contractor? Okay, hold your horses there. They can only charge you up to $500 if they are not licensed. And guys, I'm telling you, again, it comes down to the type of contractor they are, the type of work they're doing, where that kicks in. Okay. Interestingly enough, pools, we have what's called quantum Merowit. Okay. What that means is that, yes, you're supposed to be licensed, but they actually can get paid. Okay. If they're not licensed. Go figure. So, but in any event, though, in this time, the last couple of years where people are just doing home remodel jobs and improvements through the roof, those types of claims are popping up more often than not, right? And we are dealing with the very issue which I mentioned earlier, which is that, okay, the contractor, did this work. It's going to cost me $12,000 to fix it. Am I going to go to civil limited and sue for that? Or am I going to just go ahead and go to small claims and get the $10,000? Right? So we have a lot of these projects, these types of claims rather, cropping up where they're either unlicensed, or even if they are licensed, if the work just is not done according to your agreement, or if it's defective. Cool story, maybe not a cool story for the homeowner, but had a patio put in, and when everything was said and done, ended up with this big indentation in it in her patio. And I don't think that that's what she was really hoping to get. I mean, I don't know. Well, I mean, I guess if you want to be creative, it could be, she could have used it as some type of
A
a
fire pit,
fire
maybe,
pit.
or
Yeah, I'm thinking fire pit,
unless
a
it was a wood
shallow
patio,
koi
then
pond.
it's like a fire patio, and the entire thing is on fire.
Exactly, exactly. So in any event, contractors, that's huge. So that's one issue that we do see a lot of in the small claims court. We also see property line disputes, right? Or let me rephrase that, not necessarily property line disputes, but the darn fence. The fence is always an issue, okay? Who pays for the fence? The darn fence is falling down. The neighbors are fighting over who's going to pay for it. So those come up. And there's actually a statute that says, listen, guys, you know what? If you're sharing that fence, you need to share in the cost, right?
Right.
So we do see a lot of those. And I'm always perplexed as to why.
Yeah, it is really funny. Trees and fences somehow cause the most disputes between neighbors. They, it's like, it needs to be a redwood fence or a wrought iron fence or a chain link fence or a, expensive mahogany fence or whatever. And it's like, yeah. And then you see the good neighbor fences as well, where like, if you, I always kind of joke, like, if you see a good neighbor fence, at the very least, it means that you can talk to your neighbor, and they're not going to, like, make your life miserable.
Right.
That is what a good neighbor fence means.
I
Uh,
love it. I
and if
love it.
you don't see a good neighbor fence, that, maybe you want to think about moving into that neighborhood.
Yes, 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 yes. Totally agree. Um, but another issue that we're also seeing arise in is going to also be, check this out, your home warranty companies. Do you know the home warranty? You know the home, well, of course you know the home warranty company.
Yes, I
This is
do.
the thing. I thought that the home warranty companies were the best thing since sliced rice, okay? I mean, sliced bread. Guys, I'm going to put this disclaimer out there right now. I love going ahead and throwing these phrases out there. I get them wrong. I usually need my husband here to make sure like the cart before the horse, horse before the cart. I know what it is. I love using those things, but I can never get them right. In any event, I thought that home warranty companies were the best thing since sliced bread. But the problem that we're seeing more often is that the homeowners are presenting their claims. And it could be maybe there was a burst pipe, maybe more often than not, is going to be the darn burst pipe somewhere, right? And you end up with all this damage and needing things to be repaired. And, you're calling them, you're trying to get a plumber out there. Maybe the plumber comes, maybe the plumber doesn't come. Or maybe the plumber comes and doesn't do the work right, and then you end up with other damages. I mean, it's a never ending trial, for lack of a better word. It's a never ending trial, which we don't like. We don't like never ending trials. So what ends up happening is that homeowners, listen, your home warranty company doesn't want to step up, doesn't want to go ahead and cover damage, which the repair person they sent out did, or their failure to send someone out caused, because you're paying for this service, right? I mean, hey, listen, I've had it, right? Calling. Where's the repair person, right? So end up paying someone else. I want my money back. What am I paying you for every month? Right? So perfect for small claims court. Interestingly enough, but though, guys, be careful. They do have that arbitration clause in a lot of them, which we've discovered. And arbitration clauses are very interesting, right? Paid arbitration clauses.
And the
Arbitration
Supreme
clauses,
Court has.
they can be binding, they can be non-binding. What we'll generally do is, you know what, when it and let me stop for a minute. You have arbitration and you have mediation. Okay,
Right.
two different things. There is a statute that says that you can go ahead, or case law, that you can bring mediation cases that require mediation to small claims court, because small claims court is tantamount to mediation. Quick sidebar, when people go on Judge Judy, they go on these shows, they're really mediating. Okay, that's what they're doing, just so you know. But when you go ahead and you come back to, oh, by the way, I do love her. Anyway, sidebar. That was a big shout out to her, because I really do love her. Anyway, but when it comes to arbitration, the thing with the arbitration is that one becomes particularly more complicated, because there's a whole line of cases and they vary, right? They vary across the country. And it comes down to you being able to show that maybe the arbitration clause was, you didn't see it. Maybe there's a bunch of small print, it's buried, and there was no way you would have saw it. Maybe you have what could be deemed an adhesion contract, and it's in there. Unfortunately, it's going to come down to you to go ahead and make that argument that does not apply in your case. But what the judges will do, if they're more inclined to feel that the arbitration clause prevails, then they will sometimes dismiss your case. Okay, without prejudice. And mind you guys, I'm saying without. It doesn't mean they're going to do it. But
Well, so
the
what
arbitration
exactly?
clauses are.
So, just out of curiosity, what exactly does it mean when they dismiss it without prejudice? Does it mean that you can bring it back, or?
That's exactly what it means. If they dismiss without prejudice, it means you can bring it back. If they dismiss with prejudice, it means you're done. So I do want to caution you guys when we're dealing with those home warranty companies, because we are getting a lot of them. If you want to try to mediate, and this is the thing, guys, it doesn't sound the death knell. Is that right? See, I'm still getting them wrong. I'm sure that that's wrong. But it doesn't mean the end of your dispute. I prefer to go to court because I want a judge to decide it. But if you go and the judge says, hey, listen, you have this arbitration clause, I'm not going to entertain your case. I don't think this was an adhesion contract. I don't think that this was, kind of unfair to the consumer, because that's what we're looking for. Then you know what? Then you go back to, you go to arbitration. Or if you don't, then you count your loss. So that's the one tough thing about that. So kind of keep that in mind when you're thinking about the home warranty repair companies, right?
And also the Supreme Court now is starting to rethink and restructure arbitration clauses, because it's not just state law that's involved in arbitration. There's also the Federal Arbitration Act.
Exactly.
Not sure exactly how constitutionally they got to have the Federal Arbitration Act, probably the Commerce Clause or something like that. But regardless, they actually, are now sort of not allowing states to have fewer restrictions on arbitration. And so that's, something else that you need to think about. And generally, the court, the Supreme Court and courts in general really, 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 really like arbitration clauses, because it means that they have to do less work. And when you say, I say that and it sounds cynical, but considering how overburdened our court system is, anything they can do to alleviate the pressure is, really helpful.
Yeah, you know what, it is, but the tension that we're faced there is the tension between alleviating the burden on the court, right, and allowing people to have their matters, their disputes resolved quickly, right? And then also, though, the tension between consumer advocates,
Right.
because we want to ensure that the consumers have their day in court at the end of the day, right? That's what we
Right.
want. So, but it's as far as I'm concerned, I think it's like a really cool area. And so, and I am watching it as far as the different changes going on, because I don't know, I actually think that even if it says arbitration clause, and mind you, I believe if it says FAA, you can bring it in small claims court automatically. So, and I can have that off. And remember, the whole purpose of this is informational purposes only, guys. If you need the advice of
Yeah.
an attorney, call.
Yeah. I mean, I should definitely put this disclaimer out there, which I will, maybe put in at the beginning or at the end or something. But, this is not meant to be legal advice. This doesn't form an attorney-client relationship. It really is just somebody watching TV or watching their computer, getting information. And if and when you think you have an actual problem, you should get a lawyer to actually represent you to address the issues. It could be me, it could be Pam, it could be somebody in whatever state you're watching in, but oh, and by the way, we're in California. Pam is a California lawyer. So everything we're saying is applicable to California. If you are in certain other states, then other states have different laws as it relates to even small claims court. Limits for small claims court are different in different states. All of these sorts of things. So this is definitely a California specific show. Do realize that, of course, every state, as far as I know, has a court system. Every state has a court system. Every state has a sort of simplified system for smaller disputes. But different states actually have different processes and procedures and limits and stuff like that.
Yeah. And a quick side note on that, which is really interesting, is that some states require that attorneys actually appear in small claims, which I find that to be absolutely wild, right? So you could be in a state and you're suing for $1,500, but it could be a state that would require that you hire an attorney. Right? And so it's like, I don't know how I feel about that. But anyway, moving on though, another big issue that I'm finding that's popping up, and you kind of a little bit alluded to it, are homeowners associations.
They are the gift that keeps on giving to the legal system.
That's the gift that keeps on giving, exactly. So we have issues where, let's face it, a lot of times it could be a homeowners association, maybe over a condo or townhome. So then an issue is going to arise as to who is responsible when the pipe in the wall bursts. And so you're going to have the homeowner then fighting with the HOA, right? Or assessments, the HOA assessment fees, right? I have people reaching out saying, hey, I did not know I owed these assessment fees. Where did they come from? So of course, you're going to go through the regular procedure stuff, of course, in their CC&Rs, as far as, getting before the board, trying to dispute it, seeing if they can work it out, trying to negotiate it. But at the end of the day, those actions are normally ripe for small claims because they tend to be under $10,000. And it's quick, and you can be in and out of it. I have had instances where there's a dispute as to a tree. Right? Somebody's saying that the tree needs to be dealt with, and the homeowner is saying it's not on my property, and the HOA is saying it is on your property. Okay, maybe if that's not the issue, it might be a matter where the homeowner is saying, hey, that tree is a dangerous condition, it's a nuisance, it's something, and the HOA is saying the tree is perfectly fine. We're not going to touch it. So HOA, so we're seeing a lot of those cases are coming up. I think that a lot of times we are able to get those settled before we hit them, but they are definitely going to be hitting the small claims court. And then a big issue, you did also mention this one, is of course your landlord-tenant cases. Okay.
Yes, which we could do a whole show on.
We could do a whole show on it.
And in fact, we will in July.
It's gonna be fun, guys. I like to say, be there or be square. Okay, let me stop already. You guys are like, wait a minute. Somebody get that woman off of these cliches. Okay. Anyway, of note, some things to kind of keep in mind, guys, is easy stuff here. If it's a security deposit issue, most likely under 10,000, go to small claims court, regardless of the
Rapidly
size.
going outside of the realm of small claims court in the state of California, I think.
Say that again.
I said I think security deposit disputes are rapidly moving away from, the small claims court realm in the state of California, especially especially with, the treble damages. If you think that your landlord held your security deposit in bad faith, you can get 3 times the security deposit. And if your rent is $4,000, 3 times 4,000 is 12, and $4,000 is actually less than the median rent in New York City. So,
I can probably talk on that a little bit. Okay, but I won't. Okay, but
right.
but again, though, remember that that's a great point you bring up. But it also brings us back to, okay, we're going to just maybe settle for the 10,000, right? Another cool thing that happened, although I don't know if it's cool, it really depends on what side of the aisle you're on. Hey guys, I'm just here sharing the wealth. If you are a homeowner and maybe you're renting out your place and a lot of rent is owed, guess what? You're not going to be stuck to $10,000. There's a special small claims form that was created just because of this, just because of COVID. And you can get that form and you can sue. They owe you $15,000, right? $20,000. You can file. Now, mind you, there are some hoops you do still have to jump through. But some landlords may find it easier, right, to just go after the monetary damages and deal with getting the tenant out later. Right? Because right now, every time you turn around, there's a new moratorium in place. And as I understand, I believe the city of San Diego has something going on. And so can we consider this the gift that keeps giving too?
Oh yes, COVID is absolutely the gift that keeps on giving to the legal profession. And with that, though, we do have a couple of viewer questions, so I would like to move on to our last and final segment, Ask the Pro with Frantz Farreau. Hi again. And yes, I wanted to do that because some of these questions are actually interesting. So one viewer said, my English is bad. Am I allowed to bring an interpreter to court?
Oh, I love that question. Guys, sorry to tell you this, but things have changed a little bit. I'm not saying you can't bring an interpreter. However, what you're going to have to do these days is you're going to submit a form. And then it's a request for an interpreter. And listen, you submit it to the court, and the court is going to arrange for an interpreter for you. As someone who's been in small claims for a long time, I have to tell you, I'm a little bit sad about that because back in the day, we'll call it back in the day, you could bring someone, your neighbor spoke English, maybe your kids spoke English. Well, they have to be a little bit older. Okay. We don't want to bring the toddler in interpreting for you. That's not going to work. But, you could bring your older kids in, you could bring siblings in, you could bring in someone. The beauty of that was that you didn't have to wait for the court to line up an interpreter for you, right? Because sometimes it happens, you're going to show up and there is not going to be an interpreter. On the plus side, talking about the gift that keeps giving, COVID actually has basically caused us to really look at this whole way of doing business virtually, right? And so I know in another court that I work with, it's not small claims, but it's kind of cool. When we need an interpreter, the hearing officer just picks up the phone, calls a number, and an interpreter hops on the phone. As simple as that. So I know that some of the courts here, across our state are dealing with different forms of that. But definitely we'll get you an interpreter.
That is awesome. This question is actually also pretty interesting. I tried to sue my corporate landlord and they had an attorney. I thought attorneys weren't allowed in small claims court.
Oh boy. You know what? This one gets kind of complicated and I'm going to explain to you. As a corporation, you you're supposed to be you are supposed to be represented by an attorney, right? Small claims court, though, sometimes they get it wrong, right? Because in small claims court, the corporation is supposed to send a person that's knowledgeable in the business, not their attorney. Okay. Unfortunately, because we're often dealing with the civil limited and unlimited jurisdiction where that corporation better have an attorney there, the line gets blurred, right? And in this particular instance, that's where it would be really helpful to have the advice of like calling the small claims advisor's office. We have one here in San Diego, or getting with an attorney to look up that statute for you that will say, who the corporation can send at small claims court. Now, the other thing, though, to keep in mind is that if something happens and this goes up on appeal, then both parties can bring an attorney.
Actually, that brings up a really good question that we did not talk about. So you don't get one bite at the apple if you in small claims court. So what exactly is the appeals process? Or first of all, what is an appeal?
Okay, well, an appeal is this. I file an action and I don't get the result I want. And so I want somebody else to look at it. I'm going to appeal it. Right. However, there are some strings attached to it. So it's not quite as simple as getting, more than one bite at the apple. If I sue and my defendant doesn't sue me back and I lose, I'm done. I don't get to appeal. But, and this is kind of strange the way it ends up working, but if the defendant sues me back, which is what happens sometimes, especially in our landlord-tenant cases.
Right.
The tenant is going to sue to get back their security deposit. The landlord is going to sue because the landlord's going to say, hey, wait a minute, I need to make sure I didn't do anything wrong so I can keep the security deposit, right? And guess what? Now that we've opened up this can of worms, there might be other things I didn't charge you for. I'm going to throw those in the mix now. So in that particular instance, if the landlord sues you back and you end up losing, then you can appeal, and then just through the fact that you appealed, it automatically opens up both cases. And there's your second bite at the apple.
Right. Yeah. I mean, I always, when I'm teaching, I always refer to an appeal as like going to the other parent.
I love it. Love it.
You go to parent A and say, can I have cookies? And parent A says no. And then you go to parent B and you're like, can I have, parent A said no cookies. Can I have cookies? And parent B says, yes, you can, or I'm going to uphold parent A's ruling.
Yeah.
And this is what,
if I can jump in here, what's really cool though about small claims court, and I love your analogy, is that unlike the big court where that might come into play in small claims, they're not going to ask, hey, what did your dad say? What did your mom say? Right? They're going to say, let's go ahead and tell me why I should give you the cookie. And what's really crazy about that is you can say who knows what, regardless of what you said to the other person, right? What you said to the other parent. It doesn't matter, You could have told the other parent you need a cookie because, your arm is broke. You can go to this parent, that didn't work. Well, let me go to this parent. Guys, I'm not advocating making stories up, but I'm getting caught up in this, going to the different parents analogy.
Well, I mean, and I think it's, officially it's relying on different legal theories to reach the outcome.
Yes.
It's not like
that is it exactly. I love it. That's it exactly.
Yeah, but I mean, I think, and in whatever your family situation is, you can decide which parent is appellate parent and which parent is trial court parent. But but I think it's a pretty easy to understand analogy for most people.
Mm-hmm.
So I guess before we end for today, because we're almost out of time, I just want to pop your contact information up on the screen. This is how you can get a hold of attorney Pamela if you thought that she was awesome and you also feel like she could be helpful to you in some way. This is your contact information. It's really great to have. It was really great to have you as a guest. I appreciate all of our conversation. It was, a good free flowing conversation. I hope that everybody felt that they got something out of it watching the show. And again, I don't like consistently do this, but I will certainly do this kind of now. First of all, Pamela, I want to really thank you for being a guest on my show. It's always a pleasure to have you on. Also, always a pleasure to chat with you. And I also want to thank my video producer, Hunter Haddock, who has put together all of the videos. If you like the videos, that is his job. If you don't like the videos, that is also his job. So I take no responsibility for that. And I also want to say a special shout out and thank you to my social media manager, Tamara Collins, for doing all of the wonderful social media stuff that you probably see on my social media. And lastly, of course, thanking E360 TV for providing me with a great platform for having this show. So, Pamela, do you have any last words before we end for today?
Well, actually, what I would love to do is just share a little bit of tidbit with you guys about myself. I don't think I did that. I wanted to do it in the beginning. Listen, this is like my little claim to fame. I was going to say that this is my 15 minutes of fame, so thank you so much, Frantz. But guys, a little bit about myself. I was on a couple of game shows. Can you imagine that? Price is Right and Wheel of Fortune. So, yes, I know all about if you have any game show disputes. No, I'm just joking. But I wanted to share that with you. I want to really encourage you that if you do have a dispute, please reach out to myself, reach out to the Small Claims Legal Advisor's office, because there are other things that we can sometimes do that don't really require us going to court. So definitely don't feel that you have to just take it. Go ahead and see what remedies are available to you, because you might be surprised. So thanks for having me, Frantz. I appreciate you.
Thank you so much. And I will see you next week with another Real Property Pro.